let's move back to chapter 7. Chapter 7 is agency. Now, remember we talked about being a fiduciary, right? We are in a position of trust and confidence. That's what we do. Does anybody remember the 6 responsibilities that fall under fiduciary responsibilities? What are they? Obedience, loyalty, disclosure. All right. Then we need confidentiality, accounting, and reasonable skill and care. These give us our old car responsibilities, and we need to live by them. Okay, we need to live by them. Obedience, we have to do everything that our client says, as long as it's not immoral or illegal, all right, within the realm of our capabilities. We have to be loyal to our client before all others, including ourselves. We have to make sure they're taken care of. We owe full and complete disclosure to our client of anything that's abiding that could affect us and our property. Also disclosure on anything that about the person who is willing to make a purchase or about the seller. I need to disclose everything to my client. All right. What are the 3, I talked about confidentiality. What are the 3 tenets of confidentiality? What can I not disclose? There are 3 of them. There you go. Price, can't tell price that we'd accept, the terms that we'd accept, or the motivation for buying or selling. Price, terms, motivation. We need to keep those. Those are the 3 tenets of confidentiality. All right, we cannot disclose that. We have to account. How long do we have to keep all documents for our from the end of our transaction? 3 years. 3 years. We have to keep all of our transactions, right? Everything. And then we have to take reasonable skill and care, which means we need to be able to do the job, write a contract, make up showings, write a good ad to sell the property, know how to negotiate, know what our geography is, know what it's all about, know what some of the tenants are, know where to get the information if I don't know it, right? All of those things are key, critical, right, in for reasonable skill and care. Okay, so those are important for all of us. All right, now we owe third parties, we owe them what? Fairness and honesty, right? And disclosure of material facts. And we'll get into some detail about what material facts are in a minute. Okay, we need to disclose those, but we also need to be honest and fair. But do we need to give them the fiduciary tenets, the 6 of them? Not to a customer, only to a client, all right? And we need to be compliant with the license law, obviously. Now, remember, we did this towards the end of the class last week. But remember that we are a caveat emptor state. Caveat emptor means that let the buyer beware. So the seller himself, not the seller's broker, but the seller, doesn't have a single word about their property. They can sign the documents saying I'm putting it up for sale, and that's it. However, if they say something, it has to be truthful and it has to be accurate. So you're going to see that measuring a house is not, and this is the example that we use, measuring a house is not required. We don't have to measure it. It's not a material fact, the size of the house. However, we have the option to post it. We can measure it and post it. If we do, and if the seller says this is what it is, it has to be accurate. We can say nothing and be perfectly okay, or if we say something, it has to be accurate. Okay. So again, it's up to the buyer to find out all of this information or ask for it. And now the seller's broker has to give out material facts regardless. If the roof leaks in the house that I'm selling, does my seller have to say anything to the buyer about the roof leaking? Nope. He can say no representation. Can I say, do I have to say something to the buyer? I have to say something to the buyer, yes. I am not excused on caveat emptor, okay? But the seller himself doesn't have to say anything. Doesn't have to say the house floods, doesn't have to say that There is an easement. Doesn't have to say that there was an earthquake and you got a big split in the foundation. He doesn't have to say anything. As the broker, selling broker, the listing broker, I have to. If I know it, I have to say it. Okay. So again, this is really important to the fact that the seller doesn't have to say anything. Now, where am I going to get my information from? Well, I'm either going to look around. Obviously, I'm going to have an eagle eye about what this is all about. But I'm also going to need the seller to what? Be honest with me. Right? You're going to be responsible for that. What if your seller won't give you that information that you need? If your seller won't cooperate with you, do you think it's going to get any easier when the pressure gets on? I don't think so. Right? So it might be a way to find out if you're going to have a good relationship or not, or if you're going to have a relationship at all. Because if I go in and start asking the seller questions and he says, nope, not telling you, nope, I'm not telling you, nope, I'm not telling you, guess what I'm going to say? Okay, nope, I'm not taking the listing. Nope, I'm not taking the listing. I am not going to do that, right? Because I'm going to be responsible. But if he's not going to cooperate, then go find somebody else. Go find somebody else, right? So sellers also, the listing agent, do they still have to disclose the information through? Yes. Yes. Yep. Yes, you do. Even more so. Even more so. Right? So you need to be able to, get answers. You need to get cooperation. Look, if that person's not going to cooperate with you, then, you're not going to, it's going to get worse before it gets better. So you got to make a decision on behalf of you and your company to decide whether you're going to take that listing or not. Now, remember, we talked about when do we get paid? We get paid at the closing table, right? After this thing closes. So it's not all about money. Funny business. If you forget how much money you're going to make and you just take care of the person, take care of the client, they're going to love you for it. And you're going to make a lot of money because they're going to send you a lot of referrals because you're that type of person. And at the end of the year, when you tally it all up, you'd be surprised how much money you make. But if you go out there and you just worry about the money, they're going to know right away that you're not taking care of them. And they're not going to send you the referral business and all the other stuff. But if you take care of them and they take care of you, you'll do well. The problem is that you got to take care of clients who want to work with you. Right? First thing I learned when I got down here, somebody pulled me aside and said, hey, look, you know what's going to happen here? And I said, what's that? He said, some will, some won't. So what? Who's next? Right? It's a numbers game. You just want to keep going, finding the next person. They will, maybe you'll work with you. Some won't. That's okay. So what? What's the big deal? Move on. Who's next? Right? Let's keep going. It's a churn. How fast can you go? While taking care of your clients. So you got to remember, if they don't want to work with you, then move along. Move along. Because you are obligated. Okay, let's talk a moment or two about material facts. There are 4 different tenets of material facts. Facts about the property itself, that's 1. Facts relating directly to the property, that's 2. We'll go through each one of these individually. Facts relating directly to the ability of the agent's principal to complete the transaction, whether they can get financing or other. That's 3. And then the last one, facts known to be of a specific importance to the party. What's important to your client, right? So let's talk about each one of these. So the first one, facts about the property itself. How big is your property? How many bedrooms? Do you have any issues? Do you, anything about the physical property? Are you in a flood zone? Where does your roof leak, like we said before, right? Do you have a finished basement? Do you have a finished attic? Things of that nature, right? How many bedrooms? How many baths? What about, do you have on-site sewage? Do you have city water, city sewer, city water, right? All those things. Those are facts about the property itself, okay? Significant characteristics such as unpermitted space, structural defect, defective mechanical systems. Does your heat work, right? Now, the rule for heat, because I know you've been cold for a couple of nights. It was nice today, but for a couple of nights prior, your heat has to give you heat to 65 degrees when it's 20 degrees outside. That's adequate heat, right? 65 when it's 20 out. If you can't do that, then your heat needs to be bumped. It's 65. I thought it was 62, but it's 65. So that means you've got to maintain the house when it's 20 out to 65. Otherwise, you don't have it. Now, I will also tell you this. Air conditioning is not a material fact. It's not necessary. It has to be heated, but not air. It doesn't have to be air conditioning. So anything with the house, what do we need? What's wrong with it? What's anything else? Is this, do you have an encroachment? Do you have an easement? Things of that nature. Those are all facts about the property itself. Now, the second one, facts relating directly to the property. So anything outside the property that would affect our enjoyment of this property. Okay. 500 yards to the left of us is the train tracks that run all night long. And that train, every time it goes through a crossing, has to blow its horn. Is that going to affect our enjoyment of this property? It might, right? That train going all night long. What about that pig farm that's a quarter mile down the road? Or chickens or ducks or whatever, turkeys, right? If we never know about it, that's fine. But if we live in a southwesterly direction of the wind that blows past those sties, and every Thursday afternoon when they're mucking those stalls, it's unlivable here, all right? It smells bad. Is that a material fact? That would, your enjoyment of that property. What if we find out that they are changing the zoning of that property? We were all built on 1 acre. Now everything in the next phase of this property is going to be built on 1/4 acre. Is that going to affect the value of your property? Yeah, your density is going to get higher, right? It's not going to be as nice, right? Your house will be fine, but the property values are not going to, visually, it's going to be more crowded there. The roads are going to get more crowded, right? Oh, well, by the way, if we're building a new interstate and it's going to be like 500 yards off of your back fence, does that affect your property? It might. Maybe they're changing the zoning. They're going to build a new school right up against your against your property line. Should you know that? You should know that. Okay, things of that nature. So all those things are material facts about the property itself. All right, I mean about facts relating directly to the property. Anything that might happen, okay? You need to disclose those. Zoning changes, highway construction, anything else like that. We have one community here, it's got a big old 10-foot cement wall, and right behind it is the sanitation department. Not this, but the sewage treatment center. And these are nice houses. These are $500,000 homes that are up against that wall. And yet you'd never know it. Right? You would never know. There's never really any kind of, distinction there. No smell, no anything. So, it's one of those things that you might want to disclose, but doesn't affect the property really. Right? Third one, facts relating directly to the ability of the agent's principal to complete the transaction. Buyer comes in and makes an offer. What if my seller is going to foreclose? He's going to be not going to be able to, maybe he's going bankrupt. Maybe they're going to sell it before he can sell it. Those are things that's a material fact, right? If my seller is going to foreclose, if I'm the listing agent, my seller is going to foreclose in 60 days and I get an offer, I have to let the buyer's agent know and the buyer that we got like 45 days to close and get this thing put away. Otherwise, they're not going to be able to buy it. Because why? It's going to foreclose, right? Maybe we know this buyer. Maybe we know that this buyer has failed trying to get financing twice before. And they come in and they say they need to get financing before they can purchase this house. Am I responsible for telling my seller, look, they didn't get it twice before. The chances of them getting it a third time are very, very remote. They're not going to get it again, right? Or if I find out somebody was foreclosed on before and now They want to come and buy another house. The chances of them having credit are not good. Now, I don't have to tell the other party. If my client was went foreclosure and he's trying to buy the house, I don't have to go tell the seller that my client's got, my client previously had a foreclosure. But if the seller's agent finds out about it, he's got to tell his client, right? You got to tell his client. So all of those things are a necessity. We're going to learn about lis pendens, Lispendens, lis pendens, because if I'm the buyer's agent and my client wants to buy a house, or even if I'm the seller's agent, I want to go to the clerk of the court and I want to find out if there are any pending lawsuits. Is anything pending before I get involved in this? It's going to take a while. I don't want to be in the middle of this, spend all my time and money, and then lose the opportunity to sell it, right? We need to be able to do that. So, facts relating directly to the ability of the agent's principal to complete the transaction. All right, number 4, facts known to be of specific importance to a party. Facts known to be of a specific importance to a party. All right, my owner or my buyer has 3 horses. Am I going to have to find him property that'll accept those 3 horses? Sure, I'm going to have to find that. That's material fact, right? My client does paint contracting, and he has 3 trucks that he needs to park on his property. I'm not going to be able to buy a house, have him buy a house in a subdivision that doesn't allow commercial vehicles parked in the yard, right? Same thing with boats, same thing with RVs, same thing with dogs, big dogs, little dogs, right? All those things that are important to your client. Maybe, here's one, maybe your client wants to do short-term rentals and that community will not allow short-term rentals. Now, if he buys that house and you didn't tell him about no short-term rentals, he bought the house. He's not going to be very happy with you because now he can't do what he wanted to do with it, right? Now he can't do it. So again, facts that need of a specific importance to the property, okay? The importance to the property. All right, so those are the 4. You're going to have to remember those, at least work your way through them. Facts about the property itself, facts relating directly to the property, facts relating to the ability of the principals to transact here, and then facts that are specific importance to the parties. Okay, those 4, those are material facts, and you are responsible for disclosing them. Not only does this stuff have 1 red star in it, it's got 3 red stars in here, right? So the next little few pages have got to be super important. And if we go back to this one, it has all 4 of them listed on the first one we talked about, the one right after caveat emptor. All right, these are the 4 that you're responsible for. Now pay attention when you're doing those, when you're going out and you're driving around your communities. Look for zoning signs. Look to see if they're going to have any meetings about changes in zonings. Read the newspaper, find out, attend the county council meeting, or at least look what's on the agenda. See what's happening out there. Keep those in the back of your mind, because if the zoning is going to change, you got to let clients know. Those are things you must do. These are things you are not to do. These are things you are not to do. All right. And there are 4 keys here: willful misrepresentation, negligent misrepresentation, willful omission, and negligent omission. Does anybody want to tell me the difference between misrepresentation and omission? Yeah, saying it and not saying it, right? If I say something, then that's misrepresentation if it's one of these things, right? And omission is I forgot to say it. And I'll put that forgot in quotes. I didn't say anything when I should have, when I had the duty to do so. And willful and negligent, willful means that I knew. Negligent means I should have known. Okay, so these are the 4 keys. All right, so let's look at Chris Farley here for a second. If it is willful, you knew and it was deliberate. If it is negligent, you should have known and or you made a mistake. Okay, it's still your negligence. All right. Misrepresentation is you opened your mouth. You said something. All right. Tommy Boy would say you opened your big yapper. Right. The second one, omission, means you didn't say anything. You kept your yapper shut when you should have told somebody. Okay. So these are all 4 of them. Let's look at each one and then give examples of those. All right. So the first one, willful misrepresentation. And this means that the licensee, the broker, has actual knowledge of a material fact and deliberately misinforms the buyer, seller, tenant, landlord concerning such a fact. You knew that something was wrong and you lied about it. Okay, this is what's called willful misrepresentation. All right. For example, agent knows the heat pump at a listed house does not function properly, but tells a customer or a client, either one, that all mechanical systems are in good condition. This is willful misrepresentation. Willful misrepresentation. All right, let's talk about this for a second. Let's take another little deep dive here. There are 4 elements of fraud. 4 elements of fraud, okay? The first one is you have got to have lied intentionally on a material fact where a person used that information to act upon it and there was damages. There is damages. So there has to be 4 things, all right? A lie, an intentional lie, material fact, they had to use that information to act upon it and they had damages. All right, so let's use a house that's about 20 yards off the riverfront. And the rest of the houses are closer to the riverfront, but no, this one's set back a little bit. And I know it flooded. I know it flooded. But somebody comes down there, a buyer comes down there, I'm listing the property, and they said that, hey, has this house ever flooded and how serious was the damage? And I say, this house has never flooded. It's far enough back off the river. It's never gone this high. There's no water in here. You'll be fine. You're never going to have a problem with water. Okay, Sam, if you say so, we're going to buy this house. You see where this is going? I intentionally lied. I told them it didn't flood. Is flooding a material fact? I'm saying it is, right? They acted upon my statement. What happened the first time that river rose? Their house got flooded. There are 4 elements. They're going to sue me for fraud, right? They're going to sue me for fraud. Lily says a working fireplace, but then you move in and it's duct taped shut and spray painted and the agent gives you a $500 gift card. Yeah, that wouldn't be enough to pay the lawyers that I was going to have to get. That would be horrible. Yeah, that's not cool. Anyway, we go to court. And let's say that the jury comes back and says, all right, Lily, we're going to give you $5,000 for the damages for everything else. In our particular case, in the flooding, they want to get made whole, right? They want to be out of there. So if the court comes back and says, the jury comes back and says, because of Mr. Hassel's fraud, we're going to make restitution and make Mr. Hassel pay $300,000 to the buyers to get them out of that house. And the judge says, excellent, I think Mr. Hassel's a fool. Let me tell you, he looks at me in the eye and he says, Mr. Hassel, the court is expecting $900,000 from you in 30 days. I said, wait a minute, they just said 300,000. and the judge says yes, and you were convicted of what? Fraud. Fraud has treble damages in the courts. Treble damages. So whatever the jury awards, the judge triples it. So therefore, you don't want to get caught with fraud. Okay. You do not want to get caught with fraud. Now, they may want to get out of there. Okay. And you're going to have to buy them out. But yeah, leave it. So all of those things, right? So that is fraud, and that is willful misrepresentation. It's the same thing. It's the same thing. You don't want to get caught here. All right. Willful misrepresentation. Negligent misrepresentation means that you unintentionally misinformed a customer or client concerning a material fact because the agent does not know or has incorrect information or has made a mistake. I didn't do my job. I didn't find out the information before I answered the question, right? You can always say, if you wait 10 minutes, I'll get you the answer and get back to you. It's okay. Nobody's got an encyclopedic knowledge. If you got it, you should use it, but nobody's got that. So let's look at this, all right? For example, the listing agent records incorrect information in the MLS. The buyer's representative provides the MLS sheet to the prospective buyer. Okay, so the buyer's agent gives that MLS sheet. Now, the buyer's got bad information because the listing agent put incorrect information in there. Never checked the measurements. The listing agent is guilty of negligent information, right? Negligent misrepresentation in that particular case. He never checked it, should have. Okay. Another one that we see down the road, I believe we'll see that example also, is if the heat pump, every time we go into the house, it's always warm in there. It's always at like 80 degrees. And we never bother to check the heat pump, right? We never bother to check the air conditioning. If somebody says, hey, look, does the air conditioner work? And you say, yeah, the air conditioner works great. Everything's working. All the utilities are functional. And they come in and they got a $1,500 repair bill for that air handler, right? Because it's not working right. You should have checked. You should have checked to make sure. That would be negligent misrepresentation. Any limitations in reference to the time and things like this, or is it indefinite? If they can trace it back to you and you should have told them at the sale, there's no limitations. Right? No limitations. All right. Again, and that's up to the judge. But if they can trace it back, then they purchased it because of what you said. Yeah. And then everything, the key word in all of this stuff is what is reasonable. So there are 25 of us in this classroom right now. Let's all write, we don't have to do this. If we all wrote the definition of reasonable on a piece of paper, I'm relatively sure we would have 22 different definitions of what reasonable means. Again, circumstances would prevail, right? So it would depend. There's no real rock solid answer. And even in our contract, when we start doing chapter 10, 9, and 10, when I start going through the contract, page by page, all 16 pages, the word reasonable is in that contract maybe 100 times. All right, define reasonable, please, somebody. Yeah, there you go. What's reasonable? So circumstances dictate. Attitudes dictate. Whether the judge liked breakfast or not dictates. Whether he's had a bad day. You want to go early or do you want to go late when you go in front of the judge? Right? Hopefully you had a good morning. If not, whenever. All right. So it's always 50-50 when you go in front of the judge. And they play an important part of what we do. Okay, so that's negligent misrepresentation. Willful omission. All right, so the licensee has actual knowledge of the material fact and a duty to disclose such a fact, but deliberately fails to disclose it. Let's go back to my house on the river. What if that buyer never asked me about the flooding? Would I be okay just by not saying nothing? No, I can't do that. That would be willful omission. I knew a material fact. I know a fact that this house floods. I didn't say anything, and I had to do it. All right, I have to say it. So that is willful omission. All right. Agent knows a zoning change highway that would significantly enhance or adversely affect the value, but fails to disclose to the buyer. Willful omission. All right. Anything that would change it could adversely affect it. When I bought that property, there were 50 empty acres behind me. Now there's a freeway. Is that going to change the value of my property? Probably. Probably. All right. And the fourth one is negligent omission. So it says the licensee does not have knowledge of a material fact and does not disclose the fact, but reasonably should have known the fact. Okay. Seller informs me of a roof leak. I forget. I don't disclose it. Right? I didn't say anything. I put it in the MLS. That's just negligent omission. That's negligent omission. That's still, you're guilty. You're guilty. Okay? And you can end up paying restitution. I'm willing to bet that maybe more than 10 people in this classroom itself bought a property with a real estate agent, a broker, and they said, oh, this person stinks. I could have done this by myself. As a matter of fact, I'm going to go take the real, because this looks, I mean, if he can do it, anybody can do it, right? I'm sure that if you were honest, you'd say, they suck, right? A lot of it, because they did a lousy job. That's the point. You need to be better than that, because they weren't looking out for you. I mean, so if they did that to you, then you know what not to do. And they weren't looking out for you. They weren't looking out for you. And if you know what? Hey, look, we're all under a lot of pressure. We're all doing a lot of different things. And as an agent, if I say something and then a day later, I find out that that's not wrong, that's incorrect, would it do any harm if I said to you, I called you back, Lily, and said, you know, Lily, I told you something yesterday that wasn't true. Let me correct that for you. Or would it at least ease the pain versus giving you a $500 gift card and just saying, hey, you know, too bad, too sad, right? We're not perfect. We're people. We have lives. But if we make a mistake, find out. Tell your client they're a part of this, right? They're a big part of this. It's not your, none of you are going to buy it. Is that, well, maybe, let me ask this question. Will acceptance of the gift card prevent her from being able to sue? Probably, but I'm not a judge, nor am I a lawyer. So that would be a question for the lawyer. I would say, yeah, she probably should not have accepted that card. We sell houses. We don't deal with the law. This is not for a law degree, right? So that would be a case that you would get your attorney. That's why you pay attorneys. You're going to get on a first, I promise you that each and every one of you will get on a first name basis with an attorney. An attorney that you're going to be able to call and say, I got a question. I don't know. Right? Because that's the nature of the beast. That's the nature of what we do. You got to ask questions, and you're not going to have the answers. We're going to be great at buying and selling houses, but we're rather ambiguous when it comes to the law. We're going to need to know enough law so that we don't go to jail ourselves. But when it comes to going in front of a judge and they're an impartial arbiter, you're going to have an attorney friend. And we all have them. We're all going to have them. People stink. Present company excluded. All right. So anyway, negligent omission. We didn't check something. We didn't say something.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.